All right, well, why don't we go ahead and get started? Thanks everyone for joining. I'm excited to be joined here with Selena Konetkar, who is the lead contract analyst for Contract Diagnostics. And Contract Diagnostics, I've talked about a bunch. I used my last renegotiation was about a year and a half ago, and I used Contract Diagnostics and their compensation RX tool, which was a huge help. And so Selena is going to talk to us. We'll get into a general Q&A, but talking a lot about non-competes and things like that, important components of the physician contract to understand, and like we were just kind of mentioning, almost how to prepare for the exit while you're just getting started and kind of making sure you're protecting yourself. So lots of things in this arena that have been changing, and so Selena's like reviewed thousands of these contracts, and so is a real kind of expert and fund of knowledge to have here. So I'm excited to have you here, Selena. Thank you so much. And I'll pass it over to you to kind of get started. And like I said, towards the end, we'll get into a Q&A. So definitely, if questions come up, just put them in the chat, or hold on to them, and we'll have a lot of time for that as well.
Okay, hi, I'm Selena. Like Jordan said, I'm an attorney at Contract Diagnostics. I review a lot of contracts every single day. They vary by location. We work with physicians across all 50 states, and then across all different specialties as well. So again, we're very familiar with all different types of comp models, contract structures, things like that. Um, what we kind of wanted to focus on this evening were all the changes with non-competes. This is a really big sticking point for a lot of our clients. I think it's a little bit confusing. There's a lot of like misinformation out there right now. And I know, the state laws are constantly changing. It's a little bit hard to keep up with. So I thought it would be a good thing to, kind of talk through some big things to look out for with non-competes and kind of how to renegotiate your contract from there. Okay, so the biggest question I would say we get, and I think is somewhat of a misconception, is that non-competes got banned. This is not entirely true. Around last spring, in the spring of 24, the FTC had proposed a potential ban on non-competes. However, this got vacated in September of 2025, meaning that non-competes were still upheld in most states. It obviously created, a lot of discussion, possibly like, some discernment among some employers. Different states started to react differently. And I would say in the past year or so, we're starting to see a lot of states start to change the way they handle and enforce non-competes as a result of, the proposed about a year ago. So two of the really big states that have made probably the most notable changes are Texas and Florida. Texas itself is, a really massive state. I would say hands down, we see probably some of the most egregious non-competes come from this state. And, I think a lot of it just has to do one with the population, to the size of the state itself. Um, let's see, I've seen non-competes that range from 2 to 3 years in the state. I've seen upwards of 20, 35 miles, which is a lot. And, I know it's really frustrating for a lot of our clients when have entered into a contract, you're settled, you have family in the area, you don't want to completely uproot yourself, but then, you're very limited on your employment opportunities because of these really extensive non-competes. So starting September 1st, specifically in the state of Texas, um, their contracts are all going to be adjusted to have a duration limited to 1 year. Like I said earlier, sometimes these can range between 2 to 3 years, which is a relatively long amount of time. But now they're going to be reduced to a maximum 1 year, and the geographic limit is going to be a maximum of 5 miles. So if you're a physician, you live in the state of Texas, definitely something to look out for over the next 2 to 3 months. I would say by the end of September, most employers should start making these adjustments and start, kind of reducing some of the limitations associated, which is great. Really opens the door for, you to either negotiate the, current contract you're in, or, even potentially start looking at employers, which previously you wouldn't have had the opportunity to go to. But now with this new non-compete adjustment, like I said, it really opens the doors in terms of what your employment opportunities could be. Um, let's see, other states that are kind of on our radar. Florida has a new law. It's a little bit complicated to get into right now. There's a few nuances to it, but there are certain carve outs for physicians. So if you're located in Florida, this is another big one to keep an eye on over the next few months. Again, as these laws are shifting and changing, employers are reacting. A lot of them are, trying to remain compliant. I would say some are even getting kind of nervous. They're, predicting that people are going to leave, employees are going to start looking elsewhere. They're definitely going to work to retain those that they have. So just even more reason to kind of revisit your contract, reach back out to us, have a take a look at it and potentially renegotiate from there. Um, let's see what
Let
else.
me, Selena, I think actually there's Debbie put in a good question that's kind of, right in line with this. So she says, and Debbie, I'll just ask you if you either unmute and say, or you can type in the chat what state, but she's family medicine, primary care in a 3-year contract at the moment. The non-compete clause in New York includes every system in the state. So, like, what options does she have if she decides to leave? What can she do? I know a tricky thing, but like, when you have people in that situation, what are the options?
Um, I'm laughing because I think I know what employer Debbie's working for because we see this a lot, and I think it's really crazy. Yeah, I know exactly who it is because they do list every single competitor in the state of New York, and they're all the big
Yes.
competitors: NYU,
Yeah.
Mount Sinai, literally anyone you can think of. That's a really good question, and in this current moment, I don't know that I have a good answer. As of right now, there's not a whole lot of movement, I would say, with that particular employer, if I'm guessing correctly, and even in the state. But that doesn't mean that, 6 months from now or even a year from now, there won't be more federal or state changes to look out for.
And
Um,
what do you do if, let's say, someone's looking to sign, or let's say we could go back, 3 years to whenever Debbie is signing the contract and you see that non-compete. How do you how do you talk to people about negotiating that, with their employer? Because that's obviously an extremely restrictive one. Um,
right. Um, you know, Previously I had always said that, and this is before this non-compete ban got proposed, that instead of really like trying to fight your employer and have them eliminate it in its entirety, because again, prior to the spring, that wasn't an option.
mhm,
Non-compete everywhere. The way we recommend negotiating is kind of like figuring out what your exit strategy would be, or if there was a way that, you and your employer could get to a point where, there would be some sort of mutual understanding in which you wouldn't be penalized
mhm,
virtually. So what I mean by that is, don't sign a contract in which you have to go and work for a competitor. Go into it, as in I'm going to try my best to avoid it, but worst case something happens. How are you as an employer going to work with me to kind of mitigate any
mhm.
risk and kind of minimize the amount of damages that would be assigned to me?
Okay, that makes sense. Um, okay, thank you. Certainly, if
Yeah,
there's any other questions, feel free to put them in the chat. And Selena, keep going. I'm sorry for the interruption. I just thought that was
you're
uh,
good. And
very relevant.
yeah, and again, that's how I would advise previously. Like I said, now I've kind of am seeing a trend where a lot of employers are either one, reducing non-competes, or two, I've seen a good amount who are actually just not including them at all. And like I said, I think a lot of them are starting to get a little bit nervous. Um, they're trying to make contracts more favorable, make people, more willing to stay long periods of time or
Mhm.
even engage in a deal. And the way to do that is by taking out non-compete. So I would say, again, over the past 6 months, I have had quite a few clients now who are able to, either A, get rid of the non-compete, or B, reduce it to, a 1 year limitation, only
Mhm.
5 miles, only 10 miles, only have one competitor listed instead of five or six. So post spring of 2024, I would say if you're entering into a contract, I think there's certainly ways now that you
Mhm.
can negotiate and kind of make the non-compete, if they're adamant about having one in there, you can kind of tailor it to your needs.
Okay.
Are there people asking questions, Jordan?
That's what we have for now. Oh, until this contract, it was only mileage, but now systems are named. Find it very off-putting. Slipped in almost. Yeah, I agree that that's definitely like that does not seem to be a good faith negotiation or a fair thing.
No, and I would say naming systems, like I said, that one, they're a pretty big system in New York, but that's like one of the few big employers that will actually list out competitors. Um, for the most part, we normally see it as a mileage. And like I said, it's usually between 5, 10, 15, sometimes 20. A lot of states have actually mileage caps. So, like, I believe in Maryland, it can't be more than 10. I think same with a lot of like the smaller East Coast states that are kind of like more concentrated. I believe a lot of them kind of like limit the total mileage cap.
Yeah, that's the other thing I've seen like or heard from a few friends and stuff too that is especially I guess because I trained in New York City, that's where a lot of them are, but that they'll like let's say a lot of the New York systems are buying up all these like smaller community hospitals, and so they may be working at one place and then they'll say, well, it's 20 miles or whatever from any affiliated hospital. So even
Right.
ones you don't work at, and then so that ends up being a huge broad area.
Yeah, that's a good point. So whenever we see contracts, and this is like another point we advise on. So, there's a difference between having it be 10 miles from your primary place of practice or 10 miles from any affiliated
Yeah.
location. All of these places, they buy out smaller practices. There's tons of acquisitions happening. PE is notorious for coming in and buying these places, big systems do.
Mhm.
So you always want to make sure that whatever radius is listed is just from your primary place of practice. And we usually define that as a place where you see like the majority of your patient panel, where you generate the majority of your revenue.
Yeah.
That would exclude, any of those random like satellite sites or one clinic that you might go to, I don't know,
Yeah.
once a
Yeah, that makes a lot of sense. I
month.
think first I'll say I apologize if anyone hears kids screaming in the background. It's my wife is wrestling with bedtime. And then Kareem, I see your hand up. Do you have a question?
Yes, thank you, Jordan. I'll open my video. Thanks, Jordan, and thank you, Selena. This is very helpful. I'm actually in Texas, so this is very relevant to me.
Good.
And before I got the email, I wasn't even aware of that. So thanks for putting this together. My question, Selena, I have a couple of questions for you. So
Mhm.
I work at an academic institution in Texas. Um, my my contract is till 2026, so I'm
Mhm.
probably going to be, renegotiating at that time.
Mhm.
One, with this new rule, does that give me more leverage during negotiations? And my second question is, um, for renewal in 2026, because as you mentioned, I am restricted to like a 20-25 mile radius. Uh,
Yeah.
when that time comes, is it going to be just, only a 5 mile radius? So let's say, for example, I end up not renegotiating in 2026.
Mhm.
I can go anywhere that is beyond 5 miles within the city.
That's a good question. I don't know how nuanced it will be within like each employment contract. So I don't know if it's going to be like again 5 miles from your primary place of practice, or 5 miles from any clinic you're at, or 5 miles from any of their affiliates. I think that may be up to the discretion of the employer, but I think it's a really good point of negotiation for you. Is if you again have one clinic, then have it be 5 miles from just one clinic or one hospital wherever you're at. Um, but yeah, I'm not quite sure how each employer is going to choose to like adjust their verbiage. Um,
But they can't change it. They can't change it that much from the like the 5 mile stays. It's
mhm.
just depending on 5 miles from where.
Correct. Yeah.
Okay.
And you also don't have to wait until 2026 to negotiate. You can negotiate at any point in time. And, because of this rule that's changing, in the next 3 to 4 months, I feel like that's a great time to, at least begin
I mean,
discussing with them.
it's a little bit different with academics because it's just
Yeah.
the that's so okay.
Yeah. I mean, as a rule of thumb, whenever there's changes in your position or your compensation plan or your responsibilities or your call or whatever it may be, if the dynamic of your position is different than it was when you first signed, that in and of itself is an indication that it may be time for a negotiation. And again, all that to say is that you don't have to wait, and a lot of our clients don't necessarily wait until their next contract renewal, to have conversations with your employer.
But you're seeing now that employers in under those circumstances um, are trying more to retain their physicians rather than
Correct. Yeah. The cost of hiring a new physician is a lot. It's a lot to recruit, it's a lot to onboard, it's a lot to credential, it's a lot to train. It's better both for the employee and the employer to, keep the working relationship going. And in order to do that, it means that the employer has to make some concessions. Um, but I would say we're definitely trending towards, more employers willing to negotiate down, because of all the federal changes that, previously they probably wouldn't have.
thank you.
You're welcome.
And then I have Ravi sent me a message about at non-competes in Pennsylvania, and then it looks like something specific. Ravi, would you be willing to unmute and just ask, just so we make sure we get the exact gist of the question you're asking?
So, difference between like non-compete signed, like say 5 years ago when I, took the job, and if I'm
Mhm.
looking to switch with a new employer, even if I'm going out of geographic area, like with the new changes in that non-compete law that's coming up or already in place, what would be the difference? Like, should I be looking for on the new contract just to not have that non-compete at all, or that's still a thing? Like they leave it on the contract, most employers.
You're in
For
Pencil. You're in Pennsylvania.
like central Pennsylvania. And
Yeah, some employers still do have them in the state, and like I said, others have kind of like proactively remove them. I think it really just depends on the employer. Um, as a whole, though, the ones I see coming from Pennsylvania, I don't think are too limiting. Um, Again, really depends on the institution. Um, but I would say that if you're looking at new contracts, definitely, kind of take a look and see how it's currently structured, to make sure it's not as limiting. I would expect it to be less limiting now than it would have been 5 years ago.
okay, thank you so much.
Yeah. Sorry, I can't pinpoint, exactly what it is. Like I said, there's all different durations, all different mileages, counties, competitors. Every employer is different. But the way to really like protect yourself and set yourself up for success is just having it looked at prior, have an attorney take a look at it. We're happy to help you. And then kind of come up with an exit strategy based on what's there, to make sure that you have options, should anything come up.
Okay, thanks, Selena. Appreciate it.
Awesome. What else should we be aware of, Selena, related to this non-compete? And then maybe we can even talk a little bit about like some of the changes potentially to reimbursement and things like that.
Mhm. I think we covered all the big things. Let's see. Trying to think. I personally feel like because of the changes in non-competes, now is a good time for people to start kind of like keeping an eye on the market if like you're not already kind of like, be browsing job forums, things like that. Like I said, I think it really is going to shake up the market in the next year. And a lot of employers are going to be anticipating people leaving. So really, really good leverage for physicians. And I think it's definitely wise to try and capitalize on it now.
Yeah, that makes a lot of sense. That's Kareem just had another question. Is there an opportunity to negotiate compensation leveraging these non-compete changes? And kind of how would you recommend going about that?
Yeah, 100%. If there is, like I said, an employer that, you previously would have not been able to go to, and, now your non-compete is reduced, so you have a much broader range of options. I would probably start like reaching that to that employer, see what opportunities they have available, see if you can at least, get an offer. A letter of intent is a great
What's going on?
start negotiations. Um, so yeah, I think it will open up a lot of opportunities for everyone. And then, you can take those subsequent opportunities, kind of use them as leverage with your current employer, to, kind of put yourself in a more favorable position.
Awesome. And then we have another question, Vincente. Can you explain in simple terms difference between non-compete agreement and a restrictive covenant? Is it the same thing? This is an important point because they get thrown around those terms a lot.
Yeah. A non-compete agreement specifically refers to your limitations in working post-termination. So a non-compete will normally be for 1 to 2 years. The mileage will vary, or it will be a county or a competitor, but it limits the places where you can work after you leave for whatever the duration of time is. A restrictive covenant as a whole is like the overarching term. It encompasses both non-competes and non-solicitation agreements. And both of those together are your restrictions post-termination. So non-compete again is where you're limited from working geographically, and then of course a non-solicitation most people are familiar with. Just don't steal your patients or employees when you leave. But usually a very easy thing to avoid doing.
Awesome. Thank you for clearing that up. Before we get to Arthy's question, I see Frank has had his hand up a bit. So Frank, what do you got?
All right, thank you guys. I think this is quite helpful. I appreciate the chance. My question is basically two. The first one is, do we have anything coming in the state of Ohio? That is number one. And the second question has to do with, are there any specific changes with like medical directorships? So if you're in administration, is there anything that is this does it affect people who are in administration? And I will hang up.
Okay. Hi, Frank. I live in Ohio as well. Um, there's not a whole lot pending here right now. Some states do have like carve outs for, directorships. There's like some states with compensation caps. But I do not think that that is the case right now for Ohio. Again, doesn't mean, 6 months from now things won't change. But I don't see a lot of movement, at least from what I can tell right now.
All right. No, that's helpful. And I didn't really hear the very first few minutes of the discussion. Where is this whole thing coming from? Is it some sort of a federal type thing? Is it a state by state type thing?
Thank you for taking it.
Yeah. So there was a proposition back in the spring of 2024 by the FTC to ban non-competes. That got overturned in September of 2024. During that period of time, there was a lot of discussion. I think everyone was getting really excited. Employers were getting really frazzled. It really started to shake up the marketplace because, everyone thought that non-competes were going away. And then that didn't happen. As a result, a lot of changes have been made from a state level. So, like I said, all different states, like we've been talking about this evening, have all these different nuances, carve-outs, limitations, restrictions, etc. So just really key here to keep an eye on your specific state in terms of, kind of how things progress over the next year.
Okay, thank you very much.
Mm-hmm. Hey,
Sorry, I was
Jordan,
muted.
on mute.
Sorry. Arthi had another question, excuse me, a question, another Texas resident. If I'm looking to sign a new contract in Texas, should I wait until after September? Does that give a little more clarity and leverage potentially?
Yeah, definitely. Um, if you already have a contract from them, I think it's wise probably just to, maybe delay signing by a few weeks. I think you will have more negotiating power after September. So if possible, yeah, I don't think there's anything wrong with delaying it a little bit. Just until, we really kind of see how things play out. Which, I myself can't even predict. It'll definitely be interesting. So yeah, I think it's reasonable to wait.
Cool. Joy has a question too. How can I get out of a restrictive covenant? After 3.5 years, I want to leave, but company says I have to stay until January 2026.
Um, there's so whether or not an employer chooses to enforce the non-compete is up to them. Um, in rare instances, I have heard anecdotally of, people been able to work something out with their employer in which they end up not enforcing the non-compete. They, leave on good enough terms, a very good faith, goodwill effort. So if you're able to work out something with your employer, that's one way to get out of it. Um, I'm trying to think as of now, some contracts do have buyout clauses assigned, which is something I don't think we've talked about this evening. Um, Depending on what state you're located in, a lot of states will say that you can buy out the value of your contract, and as a result, they will let you break the non-compete. What it means to buy out your contract means that you basically pay the value of your contract, which is whatever like your current compensation model is valued at. Um, which for many people in this group, I'm sure is very high. So not something I ever recommend my clients do, but it is one loophole and workaround for getting out of your non-compete is engaging in one of these, like we call them buyout provisions, in which you pay them whatever X amount they decide to assign. And then as a result, they let you work within the non-compete area.
Yeah, that I was just gonna ask that if there were kind of like buyout provisions, or have you ever seen anyone sort of like pre-negotiate a buyout where they say like the buyout will be this much, so it's not as exorbitant as, buying out the whole contract?
Um, I have never seen anyone negotiate the buyout personally, and in all honesty, I don't like ever advise in like engaging in the buyout. I literally tell all my clients to like avoid it at all costs. Like, don't
Mm.
even try. I mean, like I said, it usually is the value of your contract, which is a whole year's worth of your compensation. And
Mhm.
usually they'll say, pay it back the money and we'll let you work, which like in my own personal opinion, I think it's better probably just to stick it out for a year or two and then have to give
Yeah.
up a whole year's worth of your salary. I think it's insane. And actually, ironically enough, the state of Texas is the one who was notorious for having really, really crazy buyout amounts. They used to be like a lot of times more than the actual value of your contract. And another change that they're making now is that the buyout cannot be more than whatever the assigned value of your contract is, which, like I said, is usually a year's worth of wages. So at least that's good that now, instead of having an astronomical value for a buyout, sometimes they were like 600
Hmm.
upwards. So again, a crazy amount. Now it's limited to like what your total comp is, which is more reasonable. Still not ideal. Again, I don't recommend anyone do that. I don't ever tell my clients like, oh, use the buyout because
Yeah.
it's horrendous. But that is one way to get out of it.
Okay. And then how often do you see, um, oh yeah, Karen, you're reading my mind. So, Kareem's asking from your experience, what is the percentage of actually reinforced or enforced non-competes? And my follow-up to that is like, yeah, I guess a very similar thing. So let's say like Joy was like, I got to get out of this thing. Like it's just not tenable. And if they're gonna litigate this or whatever, then so be it. Like what does that look like? Because I think a lot of people go in or people even sign contracts and go like, well, they won't really enforce it if it comes to that. And then sometimes it can come to that. So what does that worst case scenario kind of look like?
Yeah, worst case scenario, your employer does try to enforce this. It's honestly a little bit out of our scope of practice. You get into rounds of litigation, which is something that I try my best to avoid, which is why, we have all these contract discussions first, because I don't want to go to court. I never will. I don't want you guys to have to go to court either. Um, in the event that that happened, the employer usually sends a notice to your like either current or potential employer that hey, you're engaged in this non-compete. We're not going to release the employee. I think sometimes they send like a cease and desist, which is basically like a letter. Sometimes they'll file an injunction, I believe, and then it's like up to you and your employer then to either litigate. Usually you come to like some sort of mediation, they'll do some sort of arbitration, and then they'll assign a damage amount that they think is fair, and then you would, I guess, have to pay whatever the damages are, and then that's how you would get out of the non-compete.
Okay. Yeah, it's always so interesting. I guess I always just think of in sports analogy, but like the idea of a non-compete in sports would be so ridiculous, like them saying you
Right.
can't go to a competing team or something. You actually have the opposite thing where players have no trade clause, but then, doctors
No.
have like it's the opposite situation. Um, all right, any more before we go on and talk a little bit about the reimbursement stuff and potential changes and how that comes into contracts? Any other questions specifically about the non-compete? Again, in the chat, or if you want to just unmute yourself. Joy saying they did
Hi,
send
this is
the
Frank.
arrows
I
not to
just
the employer. Geez.
Jordan, can you hear
Yes.
me?
Yes, Frank, we hear
Yeah, just real quick. So my very, very first I've been in practice for about 12 years or so now. My very, very first contract, I think was so bad. I signed a contract and somehow if I did not show up, they were going to charge me $100,000. Okay. So this is not even like you've come and you want to leave, right? So you signed a contract between the time you signed a contract and the time you're supposed to start. If you change your mind, they were going to charge you $100,000.
you. Jeez.
I debated it. I spoke to a lawyer. Ultimately, they just did exactly what she recommended I do. It was such that even when I was there, I had to be there for a year and I think 1 year and 4 months before I could even ask of leaving. So not is it's not bad enough to say, okay, if you don't show up when you're supposed to, we'll charge you this much money. But then if you get here, you have to stay here literally 16 months, so 12 plus 4, before you could even ask of leaving. And not only that, it still had like 4 months in a wait out period. But ultimately, I did what I had to do because I don't know, I couldn't fight the system. I didn't have the money, I didn't have the resources. I thought I was just better off just kind of thumb my nose and kind of just do it. And so that's just what I did. Just my experience. That's all. Thank
Well,
you.
Yeah. No, thank you for sharing that. Like I said, I don't handle anything related to litigation, cease and desist, damage amounts, all very outside of my purview. But I think my biggest takeaway from all of this is don't ever engage in a non-compete thinking you're going to fight it. It's not the prudent thing to do. Go in there, thinking, hey, this is going to be my workaround. This is my exit strategy. I'll try and negotiate it down the best I can. But if not, these are the corrective actions I can take when I do get ready to leave, not, oh, it's going to be gone in its entirety, or I'll just pay the damages, because neither will really bode well in the long run.
Makes sense. All right, so shifting gears a little bit, Selena, can you just share kind of some of the background of the potential changes? Nothing is totally set yet, but the potential changes in reimbursement and how that may impact, let's say someone negotiating a contract right now, so before those changes go into effect.
Mm-hmm. Yeah, this is probably a lot more complicated than we can get into this evening. Healthcare billing is a lot. Um, there are a lot of changes in reimbursement rates. So that's, like the actual amount of money that systems are getting back for the services that are being provided.
Mhm.
A lot of the rates are decreasing. There's a lot of changes in like the actual contracts that systems are engaging with now. So from a compensation perspective, I think one, it's a really, really good idea to kind of like run a compensation analysis over the next 6 months if you haven't in a while. Ask for a printout of your RVUs, or if you're on a collections model, I would, ask for your past few quarters collections. I would ask for like a CPT schedule. And I would ask, for basically your projections from the past few months. That way you kind of know, where you are situated at. And then, dependent on how these reimbursement rates change over time, you can kind of make sure that you're in a place where you're not negatively impacted, if the rates do end up being lower than they currently are.
Oh, yeah, no, I think that makes a lot of sense. And the big, for anyone who's not kind of familiar with the potential changes, the right now, like the AMA, there's a group that sets the Medicare rates, for different procedures and office visits and things like that. And I think they're certainly not perfect at it, and that's where a lot of like the undervaluing of primary care and preventative stuff comes in. But now the idea is it's going to change to Medicare actually doing that, as all part of the sort of I guess efforts at increased efficiency, which potentially will take the locus of control away from physicians, and so that loss of potential voice is obviously concerning. So it'll be interesting to see what happens. And I think definitely we're physicians, we need to advocate for ourselves and, try to still have a voice regardless of where that, those decisions are being made. So yeah, very, very interesting time.
Right. Yeah. And, no one individual is able to control what the reimbursement rates are going to be. So, like I said, I think the best way is to now really prepare for it. Even if they do drop, at least figure out kind of where, you stand currently in practice, and then, try and, from there, figure out a way to set yourself up for success. We can kind of, predict, um, what that may be.
Makes a lot of sense. So we have a few minutes left in our 45. Any additional questions about contract negotiation period? This is, I'm not sure what the typical is, but Selena usually charges by the hour, and we've got her we've got her here and her advice for free for a little bit. So any last minute questions on kind of any topic? See anyone? All right. Well, if that's what we got, well, this was awesome. I know I definitely learned a ton. I have again my next one's coming up in about a year, so I'm kind of following along closely. So I appreciate you sharing your expertise and answering all of our questions and bringing us up to speed on everything. So thank you so much for your time, Selena. Thank you everyone for joining. I'll have this recording up on YouTube and send out a link as well for anyone who wants to review. So thank you all so much for your time.
Thanks, Jordan.
No problem. Thanks, Selena. Bye, guys.